This video lecture focuses on general competency of an individual, guardianship when someone is not competent, and the alternatives to guardianship that would allow one to avoid what can be the difficult process that is involved with guardianship. So what is guardianship? Well, it's an involuntarily imposed substitute decision maker with authority to make decisions on behalf of a mentally incompetent ward. Let me repeat that. It's an involuntarily imposed substitute decision maker with authority to make decisions on behalf of another person who's been declared incompetent. So the court is telling somebody that they are incompetent and that this other person can make decisions for them. Now, you had a reading about the guardianship of children for this module. Because children are by definition incompetent, the guardianship process is less involved. So in this lecture, I'll primarily be talking about adults who were found incompetent and have a guardian appointed. So what gives the state authority to impose guardianship on a person? Well, of the two sources of authority that we've talked about, that is police power or parens patria power, guardianship is authorized primarily by the parens patria power. That is the power to help the citizen who can't or won't help themselves. The guardianship process is fairly consistent across the country, so there's a general guardianship process that we can talk about. First, the states set a standard for when guardianship can be imposed. Most states have a general incapacity standard based upon the Uniform Probate Code, or UPC. I'll talk more about that a little later in this lecture. An appointed evaluator or examiner then conducts an examination of the person who is alleged to be incompetent. If a judge is convinced by the examiner that the person is incapacitated under the state standard for incapacity, he or she can grant the guardianship petition. Now, there are several types of guardianship. There is plenary guardianship, that's P-L-E-N-A-R-Y, plenary guardianship, which is where the guardian is given complete power over the ward's estate. This is typically done if the ward is severely incapacitated. There are also limited or partial guardianships, which give a guardian power over one or more areas. For example, someone could be given a limited guardianship over just a person's finances or healthcare decision making. You may also hear the term conservatorship. A conservatorship is essentially a limited guardianship over finances. The guardian is essentially charged to conserve a person's assets or money. So who do you think is typically appointed guardian? Across the country, courts typically first look to family members and relatives to be a guardian. This is because it is assumed that family members not only know the person's situation and values better, but also have more personal concern about the ward's well-being. In fact, the vast majority of guardians are relatives of the ward. That is 75 to 85% of guardianship appointments. In Florida, the guardianship law, which is Section 744 of the Florida statutes, identifies 12 areas of potential incapacity. A person can be found incapacitated in one or all 12 of these areas. The first area is marriage. For this area, a person should have knowledge of their marital status, understanding of the significance of marriage, divorce, and so on, as well as the legal implications of marriage. If not, they could be found incompetent to marry. Another area is voting. For this capacity, a person should have knowledge of the political process, including the right to vote, and perhaps knowledge about current political events. Applying for government benefits is the third area. A person should have knowledge of benefits to which he or she is entitled and to have an ability to initiate and complete the application process. A person can also be found incompetent to have a driver's license. This requires an understanding of the physical or cognitive limitations that might impair driving, and recent driving experiences might be considered in finding someone incapacitated in this area. Someone could be found incompetent to travel. This involves someone understanding the physical or cognitive limitations that could limit independent travel and the ability to plan or carry out trips. Someone might also be found incompetent in seeking or retaining employment. In other words, can they maintain a job and have insight into their own work abilities? There are a number of areas that we may think of when we think of incompetence, such as entering into contracts, responding or initiating lawsuits, managing or giving away property, or consenting to medical or mental health treatment. These are all in this list here of areas. Courts would want to make sure that individuals wouldn't do something that would hurt themselves in these areas, and this might declare the person incompetent to make a decision in these areas. There are two other areas of potential incapacity in Florida. The first is determining his or her residence. This one typically comes into play when someone needs more intensive care and can no longer live independently. A person may need to be moved to an assisted living facility, a nursing home, or to a group home that can provide proper supervision and care for the person. Finally, a person can be found incompetent to make decisions about his or her social environment or other social aspects of his or her life. This one involves the concern about an incompetent person being manipulated by people who may not have their best interest in mind. This could be because their ability to identify people who might take advantage of him or her is impaired, or judgment regarding getting into situations that place him or her at increased risk for harm is impaired. Now, although a person can be found incapacitated in one or all 12 of these areas, authority to make decisions in only about half of the areas can be delegated to the guardian. On this list here, those areas that are bolded, including marriage, voting, having a driver's license, traveling, and seeking or retaining employment, cannot be delegated to a guardian. And this makes sense. A guardian should not be making voting decisions or marriage decisions for a person or telling someone where they should travel to. On the other hand, entering into contracts, giving away property, determining residences, and consenting to treatment are all things a guardian can and should assist in making decisions about. The guardianship process in Florida is also stipulated by the statute. Upon receiving a petition, the court appoints a 3-member panel. The panel is to consist of one physician and 2 others who are, quote, a psychologist, a gerontologist, a physician or psychiatrist, a registered nurse, nurse practitioner, social worker, or a person with an advanced degree in gerontology or other qualified person, unquote. Florida has been considered a bit more progressive in this team approach, and each team member can bring their own perspectives and expertise into the guardianship examination and decision. The examination by the committee must include 3 components. The exam must first include a physical examination, and this is why one of the committee members must be a physician. The second component of the exam is a mental health exam. And the third component must be a functional assessment. Requiring these 3 components forces the committee to examine a variety of different issues to inform the court. In the past, the court was often just given a diagnosis and opinion of whether the person was incompetent. But having 3 people involved in an examination and requiring 3 broader components to focus on in the examination, the court is provided with more information for this important decision. So the committee provides a report to the court, and if the court agrees that the person is incapacitated, a guardian can be appointed with powers over the designated areas of incapacity. The Florida statute also offers several provisions to protect wards. First, each year a guardian must provide the court with an annual guardianship report. This report documents decisions made during the year and what the outcomes of those decisions were. The guardian is also required to provide an annual guardianship plan. The plan notifies the court of anticipated changes in the coming year and any other plans the guardian might have for caring for the ward. Guardianship hinges on a general assessment of competency or capacity. So the issue becomes, what is competency? As we discussed in Module 4 when we talked about informed consent, competence is a legal concept. It is the ability to exercise autonomy or to do something. Traditionally, it's context-based. That is, if a person is asked whether they are competent, they should respond, competent to do what? So there are many traditional examples of different kinds of competence. There's competence to marry, competence to stand trial, and competence to execute a will. Competence in a particular area is determined by professionals and judges by assessing if there are any functional incapacities that render a person incapable of making a decision or doing a task in that specific context. For example, with testamentary capacity or competency to write a will, the testator or writer must be of, quote, sound mind, unquote. Courts across the country have generally agreed that the following 4 elements must be shown to prove a sound mind. First, the testator must know at the time of making their wills that they are indeed making their wills. They can't believe that they are managing a financial portfolio, or worse, writing a novel. Second, they must know the nature and extent of their property. They don't need to know the specific dollar value, but a ballpark understanding. That is, do they have $5,000 or $500,000 in property? Third, They must know the, quote, natural objects of their bounty, unquote. For this, they need to know their children, their grandchildren, and hopefully they're aware of any spouses they might have. This does not mean that they must give them money. They just need to be aware of them. Finally, they must know the manner in which the will they are making distributes their property. Are they giving everything to the spouse? Or are they giving everything to the Salvation Army? They must understand that. So how does a court determine if these elements are met? They rely on experts, which can be a very subjective process that includes interviews, assessments, etc. So just as there are elements that go into a determination of competency to write a will, there are elements required for competency or capacity in a guardianship determination. Traditionally, capacity in guardianship was a status. It could be a diagnosis or a particular age at which a person would be considered senile. This status approach, though, is not used much anymore. Several decades ago, a group of legal scholars developed and published the Uniform Probate Code, or UPC, which was a model law that would govern guardianship in a state law. Their hope was that states across the country would adopt the same code so that there would be consistency across the country. Many states have adopted the UPC approach, which defines incapacity as impairment of cognitive and communicative abilities resulting from a status. Another approach for defining incapacity is the functional approach, where examiners assess objective behavioral evidence of functional limitations in guiding the courts in the guardianship decision. Florida uses a combined UPC and functional approach in their capacity definition for guardianship. Florida defines an incapacitated person as a person who has been judicially determined to lack the capacity to manage at least some of the property or meet at least some of the essential health and safety requirements of such person. The focus is on affirmative actions and managing one's affairs. So to manage property means to take those actions necessary to obtain, etc. And to meet essential requirements for health and safety means to take those actions necessary to provide the health care, etc. Thus, while Florida anticipates impairment as prescribed by the UPC approach, there is also great focus on behavioral evidence of functional limitations as prescribed by the functional approach. So in Florida, the three-person exam committee would first assert that the person is incapacitated under this definition, and then the committee would define the specific areas of incapacity and guardianship from the 12 areas of incapacity we listed previously. Remember, a plenary guardianship in Florida and elsewhere means power over the entire person and property. That is, all areas of incapacity allowed. So how is capacity determined? In most states, like Florida, it's a very subjective process. Experts testify to the court regarding the person's capacity. You can have more objective approaches to test various functional abilities and determine overall capacity, but again, it is still a very subjective process. Having a committee of examiners doing the assessment in Florida can provide a broader array of perspectives and information for the court to consider. Because guardianship can be such a harsh process, where a person is declared incompetent and then has powers to make decisions about their life given to someone else appointed by the court, I'd like to talk briefly about alternatives to guardianship. These are ways that a person can assert a bit more control over the process and are less intrusive than a formal guardianship appointment by the court. These alternatives include representative payees, a durable power of attorney, living wills, and a durable power of attorney for health care. These last two are considered advance directives, and we'll discuss these in much more detail in a future module, so I won't focus on them here. However, let's take a look at the first two alternatives to guardianship. A representative payee is someone who is appointed as a substitute payee for government benefits. By using this approach with government benefits, a family or other caretakers can avoid the guardianship process while still conserving the assets and resources of a person who may be declining or who is already incapacitated. All that is happening is that someone else is sent the payments from the government agency to hold for the incapacitated person. While family members can use it to help a loved one, this approach is also typically used for incapacitated individuals in nursing homes and in psychiatric residence programs who may not have family to help the person manage finances. Again, it really serves as an alternative to guardianship and is less invasive than a guardianship determination. A statute known as OBRA 1990 established much greater safeguards for selecting of and accounting by substitute payees. So it is an established and organized alternative way to ensure that an incapacitated person receives the benefits provided by a governmental agency. Please note, again, this only involves payments from a government agency such as Social Security or veterans benefits. It does not involve private pensions or private bank accounts. Another alternative to guardianship is a durable power of attorney. A power of attorney is a written agreement authorizing another person to sign agreements, conduct transactions, or perform other delegated duties on a person's behalf. The person delegates who they want to make decisions for them, so any power of attorney must be put into place before a person is incapacitated. Now, it's important to distinguish between a typical power of attorney and a durable power of attorney. A typical power of attorney ends automatically when a person dies or is incapacitated. For example, when my family moved from Pennsylvania to Florida many years ago, I gave a typical power of attorney to my real estate agent in Pennsylvania so that he could sign all the documents in the closing in Pennsylvania. He then wired money to me in Florida so that then I could close on a home in Florida. I could not be in two places at once, but the power of attorney allowed the legal process to occur because I gave the authority to another person to act on my behalf. If I had become incapacitated before that closing occurred, however, my realtor up in Pennsylvania would not have the powers anymore to act on my behalf. It's as if I had a long arm going up to Pennsylvania to sign those documents. So if I was incapacitated in Florida, he would essentially be incapacitated too and not have the power in Pennsylvania. That's how a typical power of attorney works. Someone is acting on behalf of another competent person. A durable power of attorney, however, takes care of the incapacity issue. A durable power of attorney survives the incapacity of the person who competently executes the durable power of attorney. All that's added to the power of attorney document is a single statement that essentially says, this document will survive my incapacity. But that one statement can be so important when it comes to helping avoid the guardianship process. A very specific type of durable power of attorney is called the springing durable power of attorney. This kind of power of attorney springs into effect only when some event occurs, which could be the incapacity of a person as determined by two physicians. What this allows for is a durable power of attorney to be implemented but not go into effect until a person has been determined to be incapacitated. In many states, this kind of durable power of attorney is used to create durable power of attorneys for health care. Durable power of attorneys can be very useful in the estate planning process. For example, if you know that you have a degenerative dementia such as Alzheimer's, you can make life easier for your spouse and family if you execute a durable power of attorney that gives them authority to make decisions for you when you become incapacitated. The durable power of attorney is a powerful alternative by avoiding the court system and allowing decisions to be made without a declaration of incompetence by a guardianship judge. This concludes this video lecture on guardianship and competency issues as well as alternatives to guardianship that can be implemented to avoid the guardianship process.